YouTube with the movie. This your boy Simpson Roll back at you on the business channel, and today we're here to talk about the issuer. Okay, UCC 8-201. You are the issuer. Anytime you endorse your signature on anything, you are the issuer. So if anyone gets paid, it should be you because you issued the gift. And you want recoupment and or set off of the debt obligation because once you give it to the financial institution, they're gonna do a pay to the order of on your promissory note. It's supposed to be a promissory note, but they're treating it as a draft, which is a pay to the order of, and they sign it, put it without recourse, and they sell it, which discharges you. I know I say it a lot because repetition is the key to overstand it. And 3-104D said that it can be treated as either or, but not the same. You can't say I owe you for a promissory note, but you turn around and turn it into a pay to the order of, and you get paid. No, that's why we ask for tax forms. That's why we send them these people W-9s. Because no, we want to know what you're doing. We want your EIN number. Not only that, they all have Dun and Bradstreet numbers, for educational purposes. Now let's get to it. Issuer. A. With respect to an obligation on or a defense to a security, an issuer includes a person that 1. Places or authorizes the placing of its name on a security certificate, other than as authenticating trustee, registrar, transfer agent, or the like, to evidence a share, participation, or other interest in its property or in an enterprise, or to evidence its duty to perform an obligation represented by the certificate. Go down here some. Okay. 2. Creates a share, participation, or other interest in its property or in an enterprise, or undertakes an obligation that is an uncertificated security. 3. Directly or indirectly creates a fractional interest in its rights or property, if the fractional interest is represented by a security certificate, or 4. Becomes responsible for or in place of another person described as an issuer in this section. B. With respect to an obligation on or defense to a security, a guarantor is an issuer to the extent of its guarantee, whether or not its obligation is noted on a security certificate. C. With respect to a registration of a transfer, issuer means a person on whose behalf transfer books are maintained. There you go. So, go ahead on and read it. Read all of it, because I always encourage you all to read, because this is what people are not doing. People are not reading. They want you to tell the whole game, but the power lies in reading. You have to read to understand this stuff. I might read this, 1,000 more times maybe, but I always read, whether I get to it once or twice a week, but I'm always reading to strengthen myself in this, because you have to know. You get in front of these judges or anything, you have to know what you're talking about. I don't want nobody to be like, oh, well, Simpson Road Business Channel. Oh, no, that's automatic 30 days in jail. You see what I'm saying? These people ain't playing about this. You know, that's contempt of court. But once you go in there and you know that you're the issuer, you know the game. But you have to understand your position. They are debtors in possession, undergoing the Chapter 11 reorganization, which means they're in bankruptcy. But they're looking for you to pay their bills. And once you know what you know that they're obligated to you because they are trustees. And they are in possession of contraband because the capital transfer taxes have not been paid, which means that it's all a tax issue. That's why they are billing you. They done stole everything, and they're looking for you to, pay off whatever you can, and they're gonna do the 1099-C and put all the dunge back on you. So what you have to do essentially is, report these people for fraud, waste, and abuse. This is unfair and deceptive practices. So once you know that, you're good. And I got this book right here I want to add to it. I don't mean for this video to be long, but I have to put this in. Fraud or deceit. Right there. You see it? I'm going to try to back up a little bit. Okay. Fraud or deceit. The tort most frequently committed in business dealings is fraud or deceit. In studying contracts, we observe that if one is induced to enter into a contract by fraud, he may rightfully refuse to perform. But if one is defrauded by a third party, this contractual defense does him no good. Fraud is a defense to a contract, but it is also a tort that can give rise to damages to compensate the defrauded party for the injury that the fraud may have caused him. Okay, yeah. Larceny and embezzlement. Larceny is a crime of wrongfully depriving a person of possession of something. If the object taken has a sufficient value, commonly $50 or more, the crime of grand larceny is committed by the wrongful deprivation. If the object is of lesser value, the crime is petty or petite larceny. Embezzlement is a crime of misappropriating, right here, property that already is in the custody or possession of the wrongdoer. So what does that sound like to you? That's what they're doing. Look up white collar crimes and everything, because this is what they do. I'm in law and banking, because everything is banking. This is what we have to understand, because it's all about economics and civics. It's not about nothing else. It's not about nothing else. This is what it's all about. So, I appreciate you all for joining me on the business channel. I love you all, and keep on reading, keep going through those books. All right, because I encourage it. Love you all. Take care.